transform the lives of all our citizens. Haste in the footsteps of those who are coming. These and other mercies we ask in the most humble name. Amen.
Thank you, member. Any apologies for absence?
Senator.
Okay, very well.
So we'll send it along more.
Very well. Any word from the law house? Member Cuthbert, I'm told, has indicated that she will be. She'll be absent?
Yes.
She'll be absent. All right. Welcome again, members, to this another meeting of our Joint Select Committee duly appointed to consider the Occupational Safety and Health Bill. We progress with our clause-by-clause analysis. Yes. Oh, proceed.
Right. Good morning, Chairman. Good morning,
Yes.
members.
Yes.
Mrs. Seeley Brown just asked me to convey an apology for her late arrival.
Okay.
She's on her way.
Okay, duly noted. Yes, so as I was indicating that our analysis on a clause-by-clause basis will proceed today. On the last occasion, I believe we were at part 7.
Sorry, Chair.
Yes.
Chair, you know me. Just for the purposes of records again, sir, we would have received 2 pieces of documentations. Can we just invite them to the minutes, sir, for the records?
Yes, very well, Member Gale. We have before us 2 documentation that have been served on us. One, both from the ministry. One serves as a comparative analysis, review of provisions relating to security forces in occupational safety and health legislation in select jurisdictions. The other is a extension of our another matrix, yes, dealing with the submissions we would have heard from the constabulary force and the Jamaica Defense Force. So the comments and the ministry's response accordingly. So, members, do we all have copies of this? Very well. So I believe today, picking up from the last time, the ministry, we were looking at part 7 and we had adjourned with the ministry to go back and consider whether, one, part 7 was of any relevance, and 2, if so, how it is that we intend to proceed with this part, having regards to certain challenges or the discussions that we had on the last occasion. So, Mrs. Bennett Campbell, I will now ask you to advise us as to how you intend to proceed in this regard.
Yes, good morning, members. The ministry considered all the comments that were made at the Joint Select Committee in terms of the powers of labor officers to enter. We reviewed the matter and we realized that it is valid. There's a valid concern that there will be an overlap between the OSH officers' jurisdiction and that of labor officers that could lead to some amount of confusion. We considered what would we want to accomplish in relation to the labor officers in terms of their assistance to the OSH officers. Having considered the matter, we have decided not to give the labor officers the powers to enter under the occupational safety and health legislation. What we would want from them, because we said we wanted to use their eyes, they already have jurisdiction to enter under other legislation. So to the extent that they have happen to see a contravention while they're there, they would, like they're doing now, they would refer it to the Occupational Safety and Health Department, to the director, and the full compliance tools would be in the hands of the Occupational Safety and Health Officer and Director. So this means, for example, that provisions relating to the provisional improvement notice that we had examined in clauses 90 to 102, which are similar to provisions related to the issuing of an improvement notice, we would no longer be asking the labor officer to issue a provisional improvement notice where there has been a contravention or where they have seen a contravention. So the short version is that the full remit of compliance and enforcement of this legislation will be in the hands of the director and the occupational safety and health officers.
Very well. Members? Any comment?
So with respect to part 7 then, so is the proposal to delete all the provisions in part 7?
It would have to be a few amendments. We would have had to delete the provisions in part 7, which is 115 to 131. We would have to delete provisions relating to the provisional improvement notice, 90 to 102. We would have to amend clauses 166 to 168 when we get there, but we can leave that for when we're there, because it makes reference to, delete the reference to labor officers, not the whole provisions, the reference to labor officers.
A question, 90 to 102, it will be the same thing to delete what your reference to the labor officer. It's not all the clauses.
Yes,
That's
because
clarity.
oh yes, because we had already decided that the safety and health representative would not be issuing the provisional improvement notice, so it would have left only the labor officer who would have been issuing the provisional improvement notice.
Okay.
So we would no longer have the provisional improvement notice, and I would point you to, just give me 1 second. Yes, 169, clause part 10. Clauses 169 to 172 allows for an OSH officer to issue an improvement notice in the same circumstances that you would have issued a PIN. So there was also some concerns raised about the provisional improvement notice compared to the improvement notice, because it only came down to who is issuing it. It's the same circumstances that would trigger the issuance of this notice.
Any further?
Yes, so clause 2, so as we go on, we'll point out, but I'll tell you what we have seen so far.
Yes.
Clause 208 also refers to the PIN, so we wouldn't delete the clause, but the reference to the PIN, but that's subject to other amendments when we get to that particular clause. And clause 213.3c would also be affected, which refers to labor officers. Come here. 3C, 213.3c.
Mr. Chair.
Yes,
Could I just
Mr.
ask the Mrs. Campbell just to repeat the last two provisions? I got one of them, 213.
3C and 208.
208, which is the reference to the PIN, not deletion, is
Reference to provisional
improvement notice.
Yes.
Also said 213.3c. And I must point out, it will also affect some of the schedules. So when we get there, we'll do a comprehensive. But we're just giving an idea of the main ones we have. But it's not exhaustive, because when we get to the schedules, there'll also have to be amendments there.
Yes. Members?
Understood, Chair.
Understood and agreed. All right. So I'll take it in respect of clauses 90 to 102. What we are seeking the agreement on, members, is that this part be deleted, these clauses be deleted. And 115 to 131, that those clauses be deleted too. So we agreed, members?
I'm just trying, Chairman, to identify now which area the labor officer would in fact make the report or make the reference in the scheme of things now. Which area would identify or would cause the labor officer upon being made aware of any contravention would make the report?
Yes.
And Member Gill, your question is in relation to the proposed amendment.
Yes.
Having deleted these provisions, if there's anything now in the bill to allow the labor officers to make a report,
Yes.
in the event that there's a safety and health contravention.
Yes.
We were of the view that it could have been done administratively. We didn't have to put that on the face of the legislation, because also it's not just labor officers that we'll be relying on. Other bodies that have responsibility for safety and health, the director, it is the intent to enter into MOUs to guide how they report contraventions when they see it. So it's even more than the labor officers, so that the OSH officers will have eyes out there.
In this piece of legislation, Mrs. Bennett Campbell, it has already been defined in terms of the specific roles of the OSH officer, the health and safety representative, even the person conducting business, and also any employee. It's a question now of having it entrenched in the legislation, where I wouldn't want it to be left unsaid or unclear as to, in the event a labor officer was to have referred it, that the person conducting business may indicate that the labor officer have no such powers or rights to do so under this piece of legislation, because there would have been no reference in any way, shape, or form in the legislation.
Yes. I'll allow them to time. Mrs. Bennett Campbell?
Well, because we were also thinking of the MOU with other entities and giving the power in here to enter into the MOUs in terms of contraventions and how you report it and making arrangements for that in MOUs. I don't know if it's that you wanted to separate labor officers now from the other entities who we will enter into MOUs with to report this kind of information.
The thing about MOUs is that MOUs are going to be developed between parties, and they would have been on the basis of an agreement between parties. But this piece of legislation is so expansive that it might not include everybody in an MOU. And so those who would have been outside of the MOUs, how would we capture that? An MOU is consensual, you know. We have to agree to be part of an MOU. And there are going to be some persons who I know not going to want to be part of no MOU, but we have to govern them.
Yes.
Well, maybe what we could consider, because the overarching legislation that governs labor officers is the Labor Officers Powers Act. At this point, the Factories Act was in the schedule, and we were removing that, and we'll be removing OSHA. But maybe in there we could flesh out their responsibilities in some sense in relation to reporting. Because that is really the legislation that would be the legislation governing the labor officers.
Yes, Chairman, it sounds to me that there could be a gap in accountability, which could lead to inefficiency and confusion, as I said the last time. At a point in time, we need to speak to who is accountable for what. And it seems to me that there's clarity is needed.
Yes, well, member, Webby, I think what the ministry is putting forward now is that for the avoidance of uncertainty or confusion, the certain powers of enforcement will squarely rest with OSH officers. In respect of the labor officers who I think it is well accepted that they too are visible within our places of work. And if it is that a labor officer during the course of his or her duties observe a contravention of a safety and health contravention, then it is from there now they will bring in the OSH officers who have the direct powers of enforcement. That is so.
But I think the concern from Senator Gill is that there is no specific provision in this particular bill. I would not be a specific provision that gives them that direct authority to so do. So I may ask a question then, in light of that, given the initial intention was to give them this power, to not just to report, but to actually investigate and so on. We have moved that. Couldn't we just have a general provision that say that, and I'm not a JAWS person, but the intent is a labor officer entering a premise, seeing issue of health and safety, may report or shall, I don't know how, but report to the safety OSH officer. And then from that now, the OSH officer now takes the case and move forward. But I think Senator Gay's point is that just leave it as an administrative role, then you can hold a labor officer accountable because it's basically a discretionary decision he would have. But if there's something legislation, and even the employer might say, but you have no authority to report because I don't see the legislative support. So a general provision to report, not to act upon.
I think what Mrs. Bennett Campbell put forward though is that by virtue of a consequential amendment to the Labor Officers Powers Act could flesh out what is expected of the labor officers.
Yes. On page 10, under the definitions, labor officer means any public officer authorized in writing by the minister to exercise the powers conferred on a labor officer by the Labor Officers Powers Act. So that makes reference to what you are suggesting. Is there going to be any amendment to that?
So what we have to recall is that the labor officer would not be having the power to enter under the occupational safety and health legislation.
Yes.
Right?
Yes.
Their powers would be to the laws in relation that are under the Labor Officers Powers Act. So that's why I'm saying I could not put a provision like that within the face of Occupational Safety and Health Act because we're saying they're not entering. So this definition of labor officers was really inserted because there were provisions in relation to labor officers in this act. This definition appears in the Labor Officers Powers Act. So as I was saying, if we were doing something like that, that if you have entered in relation to the act on this schedule and you have seen something, and if it would have to be labor officers if you decide to go there, it cannot be OSHA because we're saying they do not have the power to enter under OSHA. I would ideally not prefer to put it in legislation, but if I had to, it would have had to be more the labor officers' powers, which is that what the act's listed there, because that's their power now. So they would not have had the power to enter under OSHA.
I just want to, and Chairman, please, I beg of you, just to bear with me.
Yes, ma'am.
Because I may be very well the slowest person in this room.
No, you're not.
So, I'm just forming my reference based on an employer who would suggest to the OSH officer upon entering, where did you get this information from? Where did you get this information from? Who reported it? How was that report made? How were you made aware of it?
The OSH officer is not limited to entering the premises just and having to declare where I've gotten information. They're given the power to enter to ensure compliance generally. The labor officer could have got information from anywhere or could have just turned up for an inspection having given the requisite notice.
Labor officer I'm talking
Sorry, the
about.
OSH officer.
Oh,
It's OSH
okay.
officer.
All right.
Yeah, it's the OSH officer. They didn't have to declare where they got information. They have overall compliance powers. They didn't have to say that it's a particular worker. They could have been coming for just a routine examination. So they don't actually have to be entering based on a report. Mm-hmm.
Legal teams, any comments? AGC? Yeah.
Not right now, because this is something we would have to digest, Chairman. So we'd have to ask you for some time, because I'm just looking at the proposal now for the first time. So no, I don't really have any comments right now.
Okay.
So, Chairman, I'd like to simplify things from a practical point of view, right?
Yes, member.
So a labor officer enters a premises under the Labor
Officers Powers Act, yes.
Officers Powers Act, and he observes a safety issue. But he, for whatever reason, decides that it's not his obligation to report it. Who do we hold accountable?
Yes, Mrs. Manikam.
Yes, it would be that the officer wouldn't have done the functions they would have been told to do by the permanent secretary of the Ministry of Labor and Social Security.
I'm
Yes,
just thinking
member,
through
use your
terms of our
mic.
discussion, but there's nothing in any act this act here that would hold him accountable.
No, and that is why I was saying if we were doing any such thing, it would have to be under the Labor Officers Powers Act, under which they have been authorized and that which sets out their responsibilities.
Okay, so we
So
have
I
to
was
amend
not,
that.
because that is their overarching act that
Yes.
governs them.
Yeah.
So it would have to be that we're putting something there. That's what I was actually saying. It could not be on OSHA because they don't have the power to enter under OSHA.
Understood. So we're going to amend.
So we would consider if we need to amend the labor officers, because there's a consequential amendment that was brought here. We'd have to see if we still need another one. But we're actually revamping the Labor Officers Powers Act generally at the ministry. We have some amendments doing.
Oh, okay.
In terms of setting up more responsibilities for them and making consistency. So we're also doing an amendment generally in relation to labor officers.
Okay,
So what I'm saying is that this legislation would not be the proper place unless we're making a consequential amendment to the Labor Officers Powers Act under which their authority would reside.
Okay, I got you. I think I'm with you now.
Yes, members.
Your preference would be for it to be an administrative role or a legislative provision. What's your preference and why?
Well, my preference was administrative because I didn't think I needed to put on the face of the legislation that you must refer. When within the ministry already, normally you would refer to the relevant department when you see something. Because we have NIS officers entering also. We have so many under legislation. So if that's what I was thinking about administratively, that's how it has been working, in that it's not your remit. You have basic training, because we're trying to make sure everybody gets basic training in the other person's area to identify, so that it's one entity, basically. So we also have NIS officers who may happen to see something too. So if we're going to go that route, so that is why I was saying, although we're talking about labor officers here, we have employment agencies, we have different departments of the ministry who would have been entering under laws, who would have to be doing the same thing administratively.
Here,
Member Gill.
we had raised the concerns regarding the roles and functions of the labor officer, where I understood where the ministry was coming from in trying to utilize the services of the labor officers. And we saw where it would have created overlapping in terms of functions and roles, and a distinction in terms of grade levels also. And I would want the ministry to be of the view that whilst we had raised those concerns, we were seeking to water down the roles and functions of the labor officers. Now, the question that I'd like to ask the ministry, given the fact that there are going to be a revamping of the Labor Powers Act and to make it more expansive to meet the needs of the ministry, are those amendments going to be in time to give and lend support to this piece of legislation? I know the pressure the ministry is under, and you need more support. Let me make that abundantly clear.
Yes. Yes. Yes, Mrs. Medicam.
I cannot answer that at this time because we actually stepped back that amendment to actually stop to focus on this bill because of what was being required of us, because we were in advance. But it also helps us because then I would know what to do in relation to this bill in terms of the amendments shouldn't be considered then, because we thought OSHA was falling squarely. The labor officers had powers under when OSHA would have been just squarely dealt with here. So I don't think I can say it will keep a pace because I don't know what is the pace here.
Chairman, sometimes I ask a question to get a particular answer on the record.
Yes.
And I've just gotten it.
Yes. So members, what is before us is an agreement for the removal of clauses 90 to 102. Yes, let me just confirm. Yes. 90 to 102. No, they agreed.
Yes.
No, they know. They agreed.
They agreed, but Member Gill asked whether they had agreed to delete, whether they would be allowed.
Okay, fine. So I'm just reminded that there was in fact an agreement that the clauses be removed. It's just that having made the agreement, Member Gill, you had asked a question as to whether or not there would be any inclusion of any role and function of labor officers on the face of this bill. So yes?
So I'm not sure. So 90 to 102 was the provisional improvement notice provisions. I don't know if you had gotten the agreement yet to the deletion of the 115 to 131 because that is where I think Member Gill's comments had come in.
Okay.
I'm not sure.
Members, we're seeking an agreement in respect of clauses 115 to 131 that having heard the arguments from the ministry, that those clauses be removed. Yes.
Sorry. So, Chairman, with the removal of those provisions, my understanding is then that the ministry is saying they would be relying on the Labor Officers Powers Act and would be proposing some consequential amendments.
Yes.
What's the nature of those consequential amendments? Because I think you would have to have a better idea of what you intend to do under the Labor Officers Powers Act before you remove all reference to labor officers in the bill.
You see, when you said you never had no comment, that is the type of comment that is important.
Yes.
Because I just want, and why I was asking these questions, I wanted to make that same type of connection, but I don't have the ability to ask it like Ms. Aldred.
Ministry, yes.
Sorry, and if I may, because I'm looking at the Labor Officers Powers Act, I can also just make another comment to help to guide the ministry in their response. I'm looking at Section 3. Now, this is a very old act. This predates our Constitution. So forget about the 2011 Charter of Rights. This predates. This is before, this law was passed before 1962. And Section 3 says a labor officer may at all reasonable times enter upon any premises other than a dwelling house for the purpose of carrying out any inspection or inquiry which he or she may consider desirable for ensuring the proper observance of any enactment. And then it talks about the enactment which would be included in the schedule. It's vague, especially if you relate it to the OSH bill where you have several different persons and persons in the wider context, persons including companies, individuals, who have to carry out different duties and functions. When this is saying the labor officer is supposed to be ensuring proper observance of an enactment, I'm still not clear what that means. And you see, it would have been different in I've looked at, like, say, in the Shops and Offices Act, which is mentioned in the schedule. Shops and Offices Act, the actual act itself, puts in a reference to the labor officer and gives the labor officer specific powers. And that act is very dedicated, and it deals with matters relating to shops and offices. OSH is a very wide-ranging act. And so when you have a very vague section that just talks about entering to ensure observance, I think if we're doing any amendment, that would have to be clarified somewhat, because you're still dealing with constitutional right and freedom. When you're talking about entering onto a premises, even if it's for inspection, even though you're doing it for safety and health, there is still a fundamental right and freedom that you have to address. You have to ensure that you meet that constitutional test. And I think the way how this act is, it's old. It's the provisions are very, very wide, very vague, and would need they need attention, and they would need to be reviewed if we're going to if we're going to just rely on this act and not have more specific provisions in the bill.
Mrs. Bennett Campbell.
Well, the minister did not say it wanted to do a consequential amendment. The minister said it wanted it to be administrative. The committee is saying they would want us to consider. We said the only way it could be done legislatively is through that legislation, but that's not our first intent of what we wanted to do. It was to have left it administratively. In relation to Labor Officers Powers Act, it sets out general powers, and then the legislation like Minimum Wage Act flesh it out more. So a part of the amendment we're doing is that we've realized that the provisions are set out better sometimes in the supporting legislation in the schedule. So we have been trying to reconcile the labor officers with the Minimum Wage Act, those legislation that would have been actually later, that would have been more specific as to the powers to enter.
Yes,
So, Chairman, having had a little time to think about it, the AGC would not be able to support the minister's proposal to handle this matter administratively. It has to be done legislatively. It cannot be done administratively.
Yeah.
You cannot have, these are powers that interfere with persons' rights and freedoms. It's not a matter to be dealt with administratively, which is why you would have had the Labor Officers Powers Act, and which is why in some other pieces of legislation, they go further and give more detail in relation to what the labor officer can or cannot do.
Yes.
If you're going to remove everything from the bill and not mention OSH in the Labor Officers Powers Act, that is a move that we could not support.
Okay. So it is not that you're saying that the AGC has a difficulty with a proposed amendment to the Labor Officers Powers Act. The question is the extent of the amendment.
Right, and
Yes.
I'm clarifying that it's not an administrative.
Administrative.
It cannot be handled
Very well.
administratively.
Very well.
May I ask a question?
Yes.
From our perspective.
Very well.
May I ask a question for the AG? What's your view on having a specific provision in the current bill that we are deliberating here to give the labor officer that right to observe and report? Would that be something that you think would be necessary in this bill, rather than just focus on the overall labor bill for the labor officer that you say might have? We have to ensure that it's compatible.
So So I think your question would be better addressed and answered by Officer of the Parliamentary Council, but from our perspective, we wouldn't have a difficulty if there is a provision or are provisions in the bill. And again, that's the method, that's a scheme in other laws. I'm not saying it's the best scheme because it's in shops and offices in other laws. I'm not saying it's the best scheme, but it can be done. There is no reason legally why it cannot be done that way. But I still think the drafter probably would be best able to weigh in on that, knowing all the kind of changes that you're making to this bill, and noting, of course, the ministry's stated policy intention that there is supposed to be a review. There is a review of the Labor Officers Powers Act. And I had one other comment, which was, although nothing stops you from going ahead and amending the Labor Officers Powers Act to specifically address OSH, it is going to look very strange that you have only put in provisions relating to OSH alone and not address the other. So there are a number of other laws that are in the schedule. It addresses a number of other things, and if you're going to be making anything specific to OSH, it does look like a bit of a piecemeal approach. And sometimes when we're doing these types of matters, we have to be careful about how we approach trying to implement our policies.
Chair, I was having raised the concerns about the overlapping and so forth, I was simply trying to make an attempt for us to agree in even identifying provisions to allow the labor officers to carry out that particular part of its function legislatively in this piece of instrument that we're pursuing. And as Mrs. Aldred has indicated, and here comes at the right time,
welcome,
at the right moment,
yes, Cecilia Brown,
the powers that may be able to help us in our dilemma. But I was simply, my preference would have been for an inclusion of a provision to assist this process or to make that necessary connection.
Mm-hmm. Yes, Mr. Simmons?
I just want to be, maybe I'm not following all of what is going on as well. My understanding from the ministry is that the labor officers do not at present have any responsibility under the Factories Act or the OSHA Act per se. However, when they go into premises under the statutes, they do have power, and when they observe something, they then mention it to the OSHA officer, who will then take action. So this power of inspection under the Labor Officers Powers Act does not give the labor officer any power of inspection under OSHA at present. They're just there doing what they're supposed to be doing. And if they see something, they can then mention the OSHA officer. Is that the position?
Mrs. Ben Campbell?
Yes, but it's inspectors under the Factories Act who would go in and do the other parts of it in terms of safety and health, although they would have had a power to enter the premises.
Yes, Mr. Simmons.
All right, so I guess we would need time to review it, but from that perspective, I do not foresee a difficulty at this time with removing all reference labor officers under the OSHA Act. Because it's not as if they have any responsibility per se under the Act. It's just that because it could be anybody, in fact. It doesn't even have to be a labor officer. It could be a visitor to the premises. If he sees something, they can report it. So I'm not I would need time to review it, but I'm not foreseeing a difficulty with it from the LRD's perspective right now. Removing all reference to labor officer.
Very well, Mr. Simmons. Members, any further comment? Before I invite Mrs. Seeley Brown to... yeah, I know. I'm just allowing you some time to settle yourself. But what is before us, which it has been suggested that the best person to advise us is the drafters. The ministry has come back in respect of Part 7 to indicate that where labor officers are concerned, the entire Part 115 to Part 131 be deleted, and that any the intent would be for the compliance powers to be vested squarely with the USH officers. If it is that the labor officers who happens to be within the workplace observes a contravention in respect of safety and health, then his responsibility would be to report it to the USH officer, who would then take it up from there. So the issue is whether or not a consequential amendment to the Labor Officers Powers Act would allow for this, or whether on the face of this bill, we need to state exactly what the ministry intends.
Add to that, not just to state what the ministry intends, but if there could have been a provision in this piece of legislation that would allow the labor officers to make that referral.
I think it will depend, Chair, on the powers that you're going to still vest in the labor officers. Then they have powers to, no powers of entry, no powers of...
Yes, we are deleting that, clause 115 to 131, deleted, and 90 to 102, which...
Can I just clarify what is the power we have in mind? Because you want...
Yes.
So we were not giving them the powers to enforce compliance with this legislation at all. What we wanted is if they actually have entered and seen a contravention, they report it to the USH officer, director, who would follow the full enforcement mechanism.
Mr. Chair, just to, we're just having just some discussion with the AG. I just want to make it, my understanding and to make it clear, for those establishments, workplaces, etc., where the labor officer would not have power to enter under the other legislation, the USH officer in their routine expression would just have to capture that. That's so. In other words, labor officers would not be going there at all.
Yes.
Okay.
Yes. Mrs. Seeley Brown? Yes.
If it is just a matter of referral, Chair, I have no problem with it being in the legislation in that way, in the bill. But it would have to be stated in this bill. I have no problem, no issue with it.
Okay. Ministry?
If the drafter says it can go in the bill, we have no problem, as long as it is clear that they don't have this compliance. Their only responsibility is to report.
Okay.
Because we don't want the dual and the duplication.
Very well.
Just for ease of reference, sir, because I was the one who raised it, so I take full responsibility, but I never intended in raising it to cause any other confusion. It was simply to have a provision in place for it to be in the legislation.
But the point has been made, and I think we are guided by the drafters and the proposal that they have put forward. So I think in addition to deleting clauses 115 to 131, we also will seek an agreement that a clause be included that will specify that the labor officers will have some power, if we call it that, to refer safety and health contravention, yes, to the director of USH.
They would have entered, they would have also have had the entered into power to enter under USH to do this, That's what I'm not sure about.
No, based on what you have put forward, the ministry has put
I
forward.
just want to make sure.
Okay,
we're
so
the
it's,
same page.
yes.
I'm sorry, Chairman, because we were conferring, because I just wanted to be clear, what power are you thinking you'd give the labor officer? Because the labor officer has to have a power to enter an OSH establishment then. Because you're not going to have that otherwise. There has to be something that authorizes them to, because it's not just to report. For
Yes.
them to be able to report, they have to be inside.
That is so. So that, I think that is one of the clarity that the ministry is seeking from the drafters, whether or not the power to enter is under OSHA or it's under the pursuant to the Labor Officers Power Act. Yes.
Sharing with me, sir, the power to enter under that act may be unconstitutional because it's an old act and the powers are wide. So maybe we may have to put something in here to give them the power to enter until that bill is amended.
Okay.
Also, the issue I had was whether or not you were going to have been including OSH in the schedule. And I wasn't clear of that labor officers, because if OSH wasn't listed in the schedule, they wouldn't have the power to enter. The only reason they can enter other establishments is because it's listed in the schedule.
But that was my understanding.
That they would have put it in the schedule.
The amendment to the labor officers' powers would include.
So if OSH is listed in the schedule,
Yes.
then it's just a matter of tidying up that section 3
Yes.
to give them the power to enter.
Yes.
So you wouldn't have to necessarily replicate that power in the OSH bill if section 3 of the Labor Officers Powers Act is amended.
Yes.
But then you would still need something now relating to the obligations of that labor officer to report anything they see.
Mr. Chair.
Yes, Mr. Simmons, lawyers at work.
I still think maybe at this stage it is, I don't really want to give the ministry any extra work, but it probably would be best if they put in writing exactly what they expect the labor officer to do. Because I'm still, even with the proposal
Yeah, but Mr.
for
Simmons,
amending Labor
yes.
Office Powers Act,
Yes.
I still think there's going to be some problems with that. And one of the issues that we raised earlier is what really is the qualification for the labor officer to do inspections under the OSH bill.
Yes, but Mr.
And that
Simmons,
has not been cleared up as yet.
we are, what is before us today is that those powers which were originally stated in the bill will be removed. All that is expected, and Mrs. Bennett Campbell will come in after, is that the labor officer in the execution of his ordinary duties, if he observes a safety and health contravention, he is going to make a referral to the director of OSH. So,
Correct, but my
yes.
all right. Let's see what comes out of this, and then I reserve my comments for that.
All right.
But I'm still seeing a difficulty with it.
Mrs. Bennett Campbell, yes.
And I'm just also clarifying though that section 3 of the Labor Officers Act is more than entering. It is inspecting, carrying out inquiries which they consider desirable for ensuring proper observance of any enactment.
Which is in the schedule.
And those are the enactments listed in the schedule. So it may be better to actually approach this from the OSH, because this enter here is more than just what we want. It's investigation, making inquiries and all of that.
Mr. Chair,
Yes.
I'm seeking a clarity here.
Yes.
Because as I understand it, the labor officer, I don't think what we want is for the labor officer to be able to enter all premises to search for issue of safety and health. Is that under the labor officer normal routine powers to enter a premise for his or her job based on the act. If going to that premise that you have the authority already, you see the issue of health or safety, then you ought to report it to the OSHA officer. So it's not to have that authority to enter every premise just to see to report. That wouldn't make much sense. But in your regular routine duties that you already have the power to enter a premises to deal with that issue for maternity issue or so on, if you go there and there's a safety issue, then you have a overriding provision that gives you that authority to report. But not all issues, unless we are now making a 360-degree turn, circle, in the context, if that's what we want. Because you don't want to give an officer power just to enter to report to somebody. That makes no sense.
So then
Yes.
OSH should not, the schedule would not reference OSH at all then?
Okay. Okay, very well. But instead it be reflected on the face of the bill. Mm-hmm. Mm-hmm. Yes.
I didn't get that this was the policy intention of the ministry. It didn't appear that way, that what you're saying now, or what the committee is saying now, was the policy intent of the ministry. Because what it would mean is if you don't have OSH and you don't have factories in the Labor Officers Powers Act, they wouldn't be, for them to, the only OSH establishments they could enter would be only those that are listed under the Labor Officers Powers Act. So it doesn't include certain types of establishments at all. So I'm saying that I'm not sure that that was a policy intent.
Mrs. Bennett Campbell? Mm-hmm.
Well, will we state again?
Yes, Mrs. Bennett Campbell.
What we were saying is, having entered the premises that they're authorized to enter, they have seen a contravention. What we came with is we wanted them to be able to report that to the labor officers. So OSH officers, sorry. They can enter any premises other than a dwelling house. And shops, offices.
Yes.
There are certain establishments that are not listed in the schedule. They can't just enter any establishment, you know. It's not just any establishment. Read back section 3. It's not any establishment. It's any establishment governed by those laws in the schedule. Okay, so the mining establishments, for instance. No, I'm just saying, yes, but those were going to fall under OSH. So I'm just saying the bill had an amendment to the Labor Officers Powers Act to include OSH in the schedule. It was going to then allow the labor officers to deal with all of the establishments that are OSH establishments. I'm just saying this is a change in your policy. That's all I'm trying to point out. So that at a later stage, nobody comes saying, oh, I didn't understand what we were doing when we did this amendment, because it is now narrowing the scope of your policy. If you agree to take the reference of OSH out of the schedule.
Chairman,
Yes, Member Brown.
my
Welcome.
apology for lateness.
Yes, an
And I'm
apology was
meeting
taken. Yes.
elsewhere.
Yes.
Yeah. It strikes me that the current legislation, the Factories Act, contain a provision under the Labor Officer Powers Act to allow them to enter into the reference, as Debo could say, and safety issues.
but they report that to the inspectors currently. And I understand that if we change Factories Act to ash in the labor force, then they will do the same thing and report to the ash officer. That's my understanding of the policy. And I see no reason why ash can't be in the schedule replacing Factories Act, which would be repealed. Huh?
Mrs. Bennett Campbell, yes.
It could not be in the schedule in the same way, in that every act in the schedule, the labor officer has the power to inspect and inquire. So it's more than just, it couldn't be just reporting. We would have to be specific that in relation to OSH, they could only report. Because once you have OSH in the schedule of Labor Officers Powers Act, they can enter, inspect. So it would, I think it was pointed out at the committee last time, we would have been getting them in through the back door if we took that approach.
Chairman, it can be on us to write a wording that qualify what they do on the ash.
Yes, which is really what it is. And Mrs. Seeley Brown, yes.
If you're going to, so how are you going to see that there is a problem if you don't inspect? If you enter, what you're going to do? How are you going to have knowledge of the fact that you're going to still have to inspect and inquire?
Very well.
I don't see a problem. Leave it in the schedule, Chair.
Minister?
So I'm sorry, we actually didn't hear because we were
conferring. Very well.
So
very well.
actually.
No, I think what the draft has indicated is that in order for them to observe a safety and health contravention, there must be some amount of inspection. Yes, that's the point that they've made, yes. Well, which is, could be. So I think what we have before us, committee members, is just a matter of form. I think it is clearly understood what the ministry intends. So I do not know if whether we could proceed by just having an agreement for the deletion of the clauses and for a provision to be included to state exactly what the ministry intends for the labor officers to be able to do. Mrs. Seeley Brown? Yes.
Yes, member. Last week we started a discussion, and I'm not sure we're quite ended about a joint inspectorate. That's out now. I someone at the ministry raised it.
I do not believe it is out. I just think that by virtue of what is contained in OSH and the specificity, compliance and enforcement, want to vest it squarely within the jurisdiction of the OSH officers. But that position and principle has not changed.
Yeah, okay, all right.
Yes. Well, I think it's a matter of form, Member Skeffrey, but we...
I understand that's over to the drafters.
Well, that's my understanding too, Member Brown. So, yes. So we agree that, one, the clauses be deleted, two, that a provision be included that the labor officers in the execution of their ordinary duties has a power to refer safety and health contraventions to the OSH officers. So with that, then we would complete our part 7, and I see the ministry would have provided us with another matrix, and I think a comparative assessment based on the submissions that would have been made by the Jamaica Defense Force and the Jamaica Constabulary Force. So we will take that now. Bearing in mind that on the last occasion, we did agree that we are going to adjourn around 12:30. Yes, so we are going to go with the two documents. Member Clark, have you seen them? That were served on us this morning. And we'll just ask the ministry to walk us through these documents. Okay. Okay, very well. So, Mrs. Ben Campbell, you? Oh, Miss Michael. Janitor Michael, you are going to lead this part of the
comparative.
Yes.
So we had, based on the information presented by the security forces, we did a comparative analysis, and we considered what occurs in the Bahamas, Barbados, Singapore, Trinidad and Tobago, the UK, and New Zealand. So in Bahamas, they have a Health and Safety at Work Act 2002, and it allows for the minister, after consulting with interested persons, to exempt conditionally any class of persons. But what it does is, if there's a conflict with any other legislation, then it provides for the Health and Safety at Work Act to apply, the provisions of that act to apply. In Barbados, they have the Safety and Health at Work Act 2005. That act applies to all workplaces except for members of the police force or the Barbados Defense Force, or classes of persons employed by a department of government as specified by the relevant minister, and that is contained in their section 3 of their legislation. So it exempts the police and defense force in Barbados.
Be helpful.
Member, yes.
Sorry, it would be helpful because I remember the JDF had raised a concern about those persons providing support service to the army, the civilians. It would be helpful if, based on what is in the Barbados legislation, we could see the classes of persons employed by a department of government, just to see what they would have been referring to.
Yes, any response, Ms. Michael?
We're seeking to access that legislation.
Okay, so we'll revert to that. We'll proceed on. Yeah, very well. Yes, you may proceed.
So in Singapore, the Workplace Safety and Health Act 2006 and the Workplace Safety and Health Exemption Order 2006 guides their operation as it relates to OSH and the security forces. And that act applies to all workplaces as well. However, there are provisions that the act do not apply to persons specified in their 6th schedule, even if the work is carried out in a workplace. So persons exempted from the 6th schedule include any members of the Singapore force, including the Special Constabulary and the Singapore Civil Defense Force. Any workplace that is partly owned or occupied by a Singaporean armed forces is exempted. But Section 3 states that the exemption should not apply if the workplace is occupied by other persons through a lease or license granted by or on behalf of the armed forces. Trinidad and Tobago?
Yes, you may proceed.
Okay. They enacted the Occupational and Occupational and Safety Occupational Safety and Health Act 2006. Their act applied to all industrial establishment belonging to or occupied by the state. However, in case of public emergency, the relevant minister may exempt certain industrial establishments. A member of the Defense Force or police service, they do not have the right to refuse work, even where health or safety issues may exist. It is to be noted that, that similar provisions are included in Guyana as well. Section 56 of the Guyanese Act states that a worker may refuse to do particular work where he reasonably believes that a situation poses serious danger to his life or health. However, the provision does not apply to a worker who is employed in or is a member of the police force.
Chairman, just a clarification.
Yes, Member Brown.
In the comparative analysis, it says the Act applies under Trinidad and Tobago. The Act applies to all industrial establishments belonging to or occupied by the state. Is that all limited to the Trinidad legislation is, or are you just, does it apply to the private sector in Trinidad? I suspect it does. Maybe it's a formulation here that...
The specific clause.
Yeah.
Or the specific clause, yes. Mm. Yes.
But what happened is that we were referring to the state, so it does apply to the private sector as well, but for our purposes here, we're talking about what happens to the security force and the...
I take that, but just for purposes of the record here, because of what it states, we just want to make clear that we are aware that in Trinidad, it applies to the Act applies to the private sector too. And we're at one.
Well.
If it had stated that this aspect of the Act
Yes.
applies to, rather than the Act applies to.
Yes, that's the rough thing.
Based on a previous comparative analysis we had done early in the process, where we were looking at different sections in relation to Trinidad and Tobago. It applies to employers, a person who employs persons to carry out their trade, business, profession, office, vocation, or apprenticeship. It applies to industrial establishments and excludes residential premises and establishments exempted by the minister. Just for
The answer is yes, and we accept it.
Yes. Proceed, Ms. Michael.
As it relates to the UK, they enacted the Health and Safety Act of 1974. The Act applies to the Crown, but there are exceptions. The provisions which are not applicable to the Crown include issuing of improvement and prohibition notices and power to deal with cases of imminent danger. The Secretary of State is authorized to exempt the Crown by order from all or any of the provisions of the Act where it appears requisite or expedient to do so in the interests of the state and safe custody of persons who are detained lawfully. The Act applies to the Ministry of Defense, its agencies, and the armed forces within Great Britain, as they form part of the Crown. However, the Secretary of State can claim exemptions on behalf of the armed forces by virtue of the Health and Safety at Work Act, application outside Great Britain, Order 2001, and the Act does not apply to activities outside of Great Britain, such as military operations abroad. The Act also addresses application of the, as it relates to the police force, and a person who is a constable or a police cadet under their legislation is an employee. New Zealand enacted the Health and Safety at Work Act 2015. It specifies that nothing in the Act requires or permits a person to take or refrain from taking any action that would or could be expected to be prejudicial to the defense of New Zealand. It applies to the armed forces, subject to exceptions, of course, and the armed forces means the Navy, Army, and the Air Force, and does not include cadets. The Act does not apply to members of the armed forces while they are carrying out any operational activity, or they are carrying out work for the, or work is being carried out for the armed forces at a place outside of New Zealand while carrying out an operational activity. It is not applicable to any military aircraft or naval ship while they are deployed in operational activity. And an operational activity is defined to include any service in time of war, similar emergencies, or in the event of any actual or imminent emergency involving the deployment of the armed forces overseas, service carried out overseas authorized by the government, and that involves peacekeeping, maintenance, or restoration of law and order, or the functioning of government institutions, any service or activity or class of service or activity, irrespective of whether it is carried out in New Zealand or overseas, that is declared by the Chief of Defense Force to be an operational activity. Training carried out in New Zealand and overseas in preparation of any specific operational activity. The armed forces are excluded from provision in the Act relating to the election of health and safety representatives and establishment of health and safety committees. Provisions relating to the right of workers to cease unsafe work and a health and safety representative to direct unsafe work to cease cannot authorize a member of the armed forces to cease work where a lawful order has been issued, requiring work to be undertaken. And their Governor General can make regulations based on recommendations of the Minister that certain provisions of the Act and regulations do not apply to any specified activity or class of activities of the armed forces. And of course, there's consultation that will be required.
Just the New Zealand through the chair.
Yes.
The New Zealand 2015, is that an amendment? Is that really when New Zealand came to the party? Because I had thought that they would have been at the party. We are the only ones who are not at the party, but I yet to believe New Zealand was with us.
Well, that is the year that they have on the Act, so I assume that's the year. So I don't know if it was that they repealed something. I would have to look. That was there before, but that is the year of the Act.
Mm-hmm. But the other point is, Chairman, we have been out of the party for too long. 2002 Bahamas, Barbados 2005, Trinidad and Tobago 2006. From the point of view of CARICOM, we're too far behind.
Yes, Member Brown, and I think that is why we are working the way we are as a committee. Yes, to ensure that we are no longer left behind, and that we too have a Workplace Safety and Health Act. Yes. Yes. Any other comments, members?
It strikes me, Chairman, that the representation by certainly the Army, and I think it was supported by the police, may be supported by this analysis which was done by the ministry. And I don't know if this analysis also means that you are, because there's no recommendation, it's just pure analysis, bam.
There's a second document that we will move to that deals with, yes, you're a bit premature. Yes, Member Webby.
Chairman, I noticed that for New Zealand, there is a statement there that we do not see any exemptions which are applicable to the police force.
Yes,
And
police officers, yes.
Police officers, sorry. And I'm trying to reconcile that, and maybe I'm ahead of myself like Senator Brown, in terms of what is being recommended.
I think the second document which the ministry is now going to be taking us through will convey certain information in two respects, in terms of the officers and the civilian support. Yes. So you may proceed, Ministry.
So, having done that comparative analysis, we looked at what obtains in our bill, and we took into consideration the written proposal or recommendation from the JDF and the JCF. And I will just read so that what the points that we would be responding to. So the JCF raised concerns as it relates to Clause 5.4 of our bill, and I'll read. Definition of a person conducting a business or undertaking. Their concern is that the bill imposes various duties and sanctions, including criminal sanctions, on a person conducting a business or undertaking. Section 5 outlines examples of when a person will be taken to conduct a business or undertaking. There is, however, no provision or guidance in the bill as to who will be deemed to be a person conducting a business or undertaking for the purposes of the public service. For example, will it be the permanent secretaries or relevant heads of department? Section 5.4 specifically states that a person does not conduct a business or undertaking to the extent that the person is engaged solely as a worker in or as an officer of that business or undertaking. In relation to the Crown, and they went to our section 2 of, clause 2 of our bill. This
207 or 2?
207, sorry. Yes. They indicate, which states, 207 states, a person who makes or participates in making decisions that affect the whole or a substantial part of the business undertaking of the Crown is taken to be an officer of the Crown for the purposes of this Act. It can therefore be argued that since a person who makes or participates in making decisions is an officer of the Crown in accordance with Clause 207, such a person cannot be taken to be a person conducting a business or undertaking in accordance with Clause 5.4, as Clause 5.4 exempts an officer from being a person that conducts a business or undertaking. They're proposing that since the permanent secretary or head of department is a person who makes or participates in making decisions, a permanent secretary or head of department is not a person conducting business or undertaking. This, they argue, raises the question as to who or what category of persons qualifies as a person conducting a business or undertaking for the purposes of the public service.
We believed it was a valid concern in relation to, it wasn't specifically said who would be, in relation to a government ministry, who would be the PCBU, because if, based on the definition of officer, it would have excluded the permanent secretary, but we can't see how it can be somebody other than the permanent secretary. But we also think we have to revisit the definition of officer though, because some of these persons listed as officers may actually be PCBU, if you look at the definition of officers also.
Mm-hmm. Mrs. Seeley Brown, you are making a comment? Yes.
We haven't settled on the on the definitions, and one of the proposals that were made earlier is we had to decide if we're going to keep this definition or we're going to speak to an employer-employee situation. Because to me, I think clause 5 it's just confusing, and we may have some issues when it comes to interpretation because of how wide we have cast our OSH bill. So I think it may be prudent after we finish and we're going back to the definitions, rather than speak to a person conducting a business or undertaking, to just define who is an employer and who is, or you leave that normal definition and includes the Crown, so that the Act binds the Crown, and you speak to an employee situation, and that takes away all of the confusion that we have now.
Yes, and I just want to remind you why the bill has somewhat shifted away from the definition of the employer-employee as detailed in other legislation, and the challenges which that definition has presented. Ministry, I don't know if you have any comment by virtue of what, but I take the point that the definition section will have to be, we have not dealt with it as yet. Mrs. Benny-Campbell, you have heard.
Yes, from a policy standpoint, we were always trying to be wider than the traditional employee, if you notice the definition here, because the persons we have here would not be employees normally. An independent contractor would not be, for example, considered to be an employee. So that would be the challenge, because policy-wise, because of safety and health, we are definitely trying to capture a wider set of workers. And so if we use traditional employer, it won't work with the wider definition of workers.
Fine, I'm hearing you, but then we have to, when we going through it again, because you have seen, we have seen the issues that, many issues that has been created with all these different definitions. You can have a separate part in the bill that speaks to an independent contractor, and what are the duties or what are the, the obligations and liabilities of an independent contractor outside of your employee situation. I'm just saying, if we are, because really and truly, when you read this whole definition of persons conducting a business or undertaking, it doesn't fit into what obtains in the civil service. And that is the problem we may have, because this act binds the Crown. So I'm just saying that let us keep an open mind, because we're going to be restructuring the bill. Let us keep an open mind as to how we're going to craft these definitions and, what we intend to cover in doing so. That's all I'm saying.
Chairman.
Member Brown.
Yeah. I'm thinking of Villa Road Primary, where there's an accident recently while we sat here in Manchester. And I think Senator Skeffel want me to be more specific. In Mandeville, Manchester. Who is responsible? The principal, who then would be the person there, or the PS, who is also person responsible. And so that's a dilemma where we have this situation. Is it Senator Webby from Grace when something happened in Santa Cruz at a location, at a supermarket or one of the things? So that's one to be clear. And I recognize that 207 may be trying to capture the public sector with its with the vagaries of its management system. And maybe what we want to look at and to consider is whether or not some wording like notwithstanding, at 207 when we get there, notwithstanding 5.4, this applies. And especially since it's going to be for the Crown. That may be a formulation which you could look at, because the way business is set up in the private and the public sector may be different, and so we could capture the public sector later on, but this would be good for everybody else.
Yes, Member Gill.
You see, I want to understand in my mind, because the reference to the ministry's response suggests, in our view, clause 5.4 will have to be deleted, and same will lead to confusion. So you're suggesting to delete 5.4?
At this point, but at this, what I have in pen here,
Yes.
I want to revisit when we get to 207 and when we're
Right.
defining officer. So I wouldn't want to move for a deletion at this point.
Okay. That I can understand. And it all comes back, Chair, when we go back to that important part of our review, the definitions. Because that I can appreciate the extent of 5 in seeking to be as expansive as possible in terms of capturing who really conducting business. No, I can understand that aspect of it, because the permanent secretary is an officer and is an employee. And this is where now I am to be guided where, where the crown would come in. But I can understand and appreciate the extent to which we want to have as wide coverage as possible in terms of 5, to include even subsidiaries. You see, like how Grace is a big company and it have subsidiaries all over the place.
47% coming from
Right? But I believe JPS in their submission had raised a concern in terms of outsourced entities that would have to carry on functions that they demand in meeting their objectives. But somebody has to be held accountable in the event of an unfortunate accident.
Member Skipper.
Mr. Chair, it's critical when we talk about binding the crown, and where we have our public institutions, how you come about who is responsible. Senator Brown asked a question, I didn't hear an answer. I was hoping for an answer for the discussion purpose. But in the school system, and that specific example he gave was a real example, somebody died. So we are saying in that school system who is ultimately accountable. And if you want to be even more specific, even in the school system, the principal could say, but my bursar is in charge of that aspect of the plant, for example. so where does it end? Yes. And they are all employees of the state. So they are not in the strictest context of conducting the business and so on. They are also employees. So I think I want to get more understanding as to the intent here and how you can apply it practically. Because at the end of the day, you can have the fancy provisions and the wording and so on. But if you're not able to hold anyone accountable, then the bill, when become law, will not achieve the objective. So from the public institutions, I can see it working more in the private areas and so on, but from a public institution point of view, in the hospitals, for example, where we have these accidents taking place, you have the matron, the chief medical doctor, the CEO, a complex, sometimes bureaucratic structure. Where does the buck stop?
Yes, Member Clark, before you come in, I just respond to Member Skipper briefly though, because I know the ministry ultimately will respond and even the proposal put forward by Member Brown. But I think what is contemplated here is that in those circumstances, an express provision to say that the permanent secretary is where we need to go or to whom we need to look. That is the consideration as stated here by the ministry. Whether or not it is, yes.
Yes, who says the minister?
No,
Yeah,
I would
yes.
just ask for caution, because when we're talking about responsibility of the crown has a very specific meaning in law. We have our Crown Proceedings Act. These are not things that need to be replicated here, because that governs who can be sued, how you sue them, and we have, on top of the legislation, we have very clear and specific case law and guidelines. So, for instance, when the Crown is liable, it's the Attorney General's Chambers, Director of State Proceedings, are sued. But again, I'm asking for caution about how you interpret the term the Crown, because I hear some discussion, and yes, it is true that there are a number of those entities that would fall under the responsibility of the government. But in the day and age of wider public sector, Not everything and not every entity, not every person falls under the Crown. It's very specific. So the bill will need to make it clear about where the responsibility will lie, because the Crown will not be accepting responsibility where the Crown is really not the responsible entity. And I just want to make that clear, and that's the response from the Attorney General's chambers. We also had a number of comments throughout. So where the Crown is mentioned, there needs to be some tidying up because there are some inconsistencies with the Crown Proceedings Act, and that we're going to be pointing out, and we don't need to reinvent the wheel in relation to matters such as that. If it means that there is a loophole, then you address it. If it means you think that someone is not going to be covered under the rubric of the Crown, then you ensure that you make some other provision for it, but not to expand this definition and understanding of what the Crown is and who represents the Crown and all of that.
Well said, Sergeant. Member Clark, I recognize you.
Thank you very much, Mr. Chairman. The energy within the question that I wanted to ask has been precisely answered by the deliberation just now by Madam Aldrich, so I am clear on it.
Very well. Minister?
Well, we were always aware that there are concerns about provisions in relation to the Crown, because Solicitor General has always said so. So we always intend to work and address that.
So we will be guided by the Solicitor General when we get to that, when we revert to provision 5 and the clause dealing with definition, in addition to clause 207 when we get there. You may proceed, Ms. Michael.
Clause 18. The concern was that the section outlines factors that should be taken into account when determining the meaning of reasonable practicable in relation to the duty to ensure safety and health. It is recommended that for members of the security forces such as the JCF, an additional provision is to be inserted which recognizes that it is not possible to guard against or to foresee all possible harm given the particular dangers and risks that are inherent in the duties of the members of the JCF.
Yes, proceed.
So clause 18 says, well, I'm not going to read all, I'm going to start. In this act, unless the context otherwise requires, reasonably practicable in relation to a duty to ensure safety and health means that which is or was at a particular time reasonably able to be done in relation to ensuring safety and health, taking into account several factors that are listed in A to F. So we were responding that we believe that the words that which or was at a particular time reasonably able to be done in relation to ensuring safety and health was trying to cover those factors where it's not, you're just doing the best that you can do in the circumstances. So we were of the view that this should address, that was intended to capture situations that were pointed out by the JCF here.
Mrs. Hildebrand, any comment? Who's making the ministry?
The comments.
Right,
I think
right.
the point that they're making in relation to the use of the term reasonable practicable when it comes to those type of officers. How we're going to address it, I'm going to have to give some more thought to that.
In respect of the ministry's comment, do you have a response? Do you have any comments?
Mr. Chair, I think
Yes, members.
while we look at the
Yes.
concerns of the JCF and the JDF, in terms of how we deal with it, the first thing was asked, are we going to give them exemption from the bill in totality? If we come to that decision, then we don't have to address.
Okay.
So we need to make a decision as to how we treat the JDF and the JCF
First.
with respect to the bill.
First, and then
If we're going to include them, then
yes.
we have a more pressing issue to deal with the special provision, but we're not going to include them. We have no issue.
Just to recall, though, that the exemptions were not singular to the security forces. The JDF had sought also exemptions to certain civilians, and we have to make a determination if, in the interest of protecting workers, how far we are going to proceed in relation to the application of any exemption.
Yes, Mrs. Sullivan.
When you read what is captured here, we still may have a difficulty fitting it into this category. You understand, some sort of guideline.
Yes.
So it depends on whether we're going to exempt them or how we're going to. I'm not comfortable that these words alone may suffice. Yes.
It's not a question, Chair, that you can partially exempt, or you determine if and when they are included.
So, Ministry, based on the deliberations, take us to the specific section of this matrix that deals with that issue of exemption.
19.3A. So the JCF raised concerns as it relates to 19 clause.
Could you take us to the page of the matrix so that we... Yes. Okay, very well.
Yes, the ministry was actually, from a policy standpoint, not trying to go for total exclusion or exemptions, but for exemptions in relation to certain clauses or to make allowances where necessary based on what has been proposed. So we were not proposing a total exemption.
For JCF or for both? For both.
So remember, in the other document of the comparative analysis, the Barbados legislation defines certain classes of persons employed by Department of Government. So that's why I'd asked for that, to see what that schedule would look like, to see if it would assist us in any way, shape, or form in making a determination.
We have to do more research because it's actually by order, so we'd have to check if that minister actually made an order. The Barbados, it was by order of the minister. So we have to check to see if an order was actually made. It's not a schedule, it's an order.
Yes. Member Brown?
I am moving towards exempting the Army, and I'm minded to look at the civilians who work with the Army, to put some amount of protection there for them under the legislation. But where operations have been declared by the Chief of Defense Staff and the training, I'm prepared to exempt. That's where I am at.
Good morning, Chair.
Member Longmore, yes.
Thank you. I'm just curious to know if there was any thought to see what happens in the jurisdiction of Canada. For a number of reasons. It is a commonwealth as ourselves. They're on the same hemisphere as us. They're a first world organization in terms of where they would be taking their security concerns and protection of their personnel. And I just find that in my limited experience with legal issues that with respect to Canada tends to be very up to date and in keeping with what is happening with international concerns. So I'm just curious to see what is the approach there, where particularly something of this nature in terms of the protection of the service, the persons who are providing such a critical service would obtain.
Member Longmore, as you, from this document that we would have been provided with, yes, so we have 2 Commonwealth countries there, and 3 CARICOM.
Right.
Well, we have Barbados and Trinidad and Bahamas.
But Canada is
And
only
Guyana.
and only 2 first world, 3 first worlds,
Yes,
and those 3 are on other sides of the world.
yes.
Canada hits all 3 for us. So that's why I would suggest
Yeah, well,
that we
the ministry will respond. Mrs. Bennett Campbell, I don't know if you have that information.
Well, from what I can see in Part 5 of their Ontario Occupational Health and Safety Act, right to refuse or to stop work where health or safety in danger does not apply to a worker described in subsection 2A when a circumstance described in, well, certain clauses here is inherent in the worker's work or is a normal condition of the worker's employment, and when the worker's refusal to work would directly endanger the life, health, or safety of another person.
Mrs. Bennett Campbell has a difficulty hearing you.
Oh,
We're asking you to speak through using the mic.
Hold on, 1 second. Right. In relation to the refusal to work, I'm looking at the Occupational Health and Safety Act, Ontario. We had modeled it in relation to some of the amendments we proposed in relation to the right to refuse unsafe work. It doesn't apply to a worker described in subsection 2, that's the right to refuse or to stop work. When a circumstance described in, and it said certain clauses, is inherent in the worker's work or is a normal condition of the worker's employment, and when B, when the worker's refusal to work would directly endanger the life, health, or safety of another person. So the workers they're speaking about would be a person employed in or a member of a police force to which the Police Services Act applies, a firefighter as defined in subsection 1.1, and then they have persons that are more similar to what we call our essential services here. Yeah, correctional institution, place of secure custody designated, and they go on to list. So it's in relation to right to refuse work, but I'll have to do some more research. I know I had read it at the time. There was a reason I didn't put it in, but I need to refresh my memory and get back to you just to be comprehensive.
Just from what you're saying, it sounds a bit more all-encompassing, even in terms of relating to the firefighters and such, which I have not heard mentioned, and other critical services. So I think I would love to hear a bit more of that detail.
Well, what they have is because our firefighters are essential services. So we had looked at that earlier when we were looking at 85 and the right to refuse work and essential services, because that's who we would call essential services. So what we're looking at now is specifically the JDF and their equivalent of the Army and police.
The description of the right to refusal here, I prefer how it's worded here versus...
Well, we did try to lead an amendment similar to this in relation to the inherent in the worker's work. So when we had done 85 to 89, we had tried to go nearer to this language here.
Okay.
But without the exclusions, but where it's inherent in your work, then you couldn't refuse work. So we tried to go nearer to that in the amendments we had proposed in the matrix. I don't remember the date.
Okay.
Reminded.
All right, thank you.
Very well. Member Gill?
Again, so we're talking about 2 entities that are seeking exemptions. And when you're seeking an exemption, it means also, in my mind, that you'd want to exclude yourself. And it was these 2 entities who had cited that they had, based on questions that we had put to them, that they had policies that governs health and safety. And we had asked to review, to see those policies, because whilst you're asking for exemption, you must have some regulated guidelines that govern how you protect and how you conduct health and safety. So before I wade into any notion of of supporting any exclusion. I would want to see what is there that protect these workers in terms of their own internal standards. I remember the JDF citing that theirs was very regimental in nature. And so I'm still putting it out there that we'd want to see what it looks like.
Any other comments? Ministry?
Maybe they could be, I know the committee had mentioned wanting to see the documentation, and I don't know if the committee wants to ask the JDF to supply that documentation so that they could make an informed decision. Because I remember it was asked, but
I'm just reminded that what the JDF had indicated is that there was no single comprehensive document containing these safety and health procedures, but they are contained in standing orders. And as such, if it is that we were seeking, and the standing orders also may contain other things that they would not want to disclose at this level. So I do recall they expressed a certain concern in respect of the form in which these procedures were contained.
Well,
Yes.
Chairman, they did agree that they are subject to the parliamentary decision. And we did ask them, can't compel them, but we did ask them to call from the various standing orders some of these provisions so we could see them. And we could even consider making them part of a schedule as such, so that we don't leave those people out of the safety. Yeah, we understand their concerns about operational things, etc., but we need to make sure we not leave any soldier behind. I think that's the Marines thing.
Well, in that regard, what will happen is that we will issue a letter to the JDF reminding of, the request of the committee to which they had consented at the time. So we will be issuing a follow-up letter to the
Chairman,
JDF.
you see, it goes two ways. Remember, they have made that request. We invited them to come here and they didn't come, and we had to somehow almost instruct. And when they came, that is when we became aware of their concerns. But also, whilst the security forces have their standing orders, I also want to know what the civilians have in terms of their own protection. Because in my mind, one of the submissions that was made by the JDF, and I can be corrected, I can understand where support might be extended for certain excursions or patrols. But there was a submission made that for the preparation of meals in the event of an accident taking place in the kitchen, where if that event was to have taken place, there would have been an investigation and the ministry would have to come in. But they were saying, but you have to prepare me a meal for me to go to do the excursion. Anyway, I mean, that's the way it came across in my mind. So I have to be very clear when you're asking the Parliament in this review to make a judgment in terms of something dealing with an exemption, that we have to be very thorough in making that determination.
Chairman, I just want to add to what Senator Gill said.
Yes, Member Brown.
And I do this conscious of a call or a series of calls I got recently from civilian employees who is now in contention with the JDF over, and I believe a certain office that sits near, over an accident. And there seems to be no provision to protect those civilians. And so we're not talking in abstract here. There is a particular case, and maybe well, I don't want to go into the details of it, but I believe that our general office is aware of the case. I don't know if it's one or more, so this is a real issue we're talking about here.
And I just remind you, members, that what we really have before us is not for us across the board exemption. What it is saying is that where civilian workers are concerned, the act will apply to them. But for the officers, you know, the exemption is being contemplated.
I hope you said that, Chairman, because remember the JDF wanted a total exemption for all workers. So I'm glad to put that clarity there. And therefore, it's going to be important now how we word such provisions to have that clear separation is critical.
Very well. Minister? Yes.
Minister, we're not so sure how to proceed now because we were proceeding more on a clause by
clause. Okay. Yes.
Opposed to a general.
Yes. So I think where we had adjusted somewhat, members, is based on the submission that members Kefri had made, that the position of the committee in respect of and the ministry in respect of the exemption granted to the JCF and the JDF should first be looked at, and thereafter now that would influence how we consider the rest of the submissions that they had put forward. So I think, Member Gill, you have raised a point about the submission, the further documentation that the JDF was to provide, having compiled, from the different standing orders. So I do not know if that has interfered with the committee's ability to proceed with this document, or we should wait until the submissions have come from the JDF, then we will continue in this regard.
A request can be made of them, sir, if they could. Just these specific areas that relates to health and safety, if it's permissible on their part to submit to us for review. And the civilians.
Yes, but I did ask, how does it impact by virtue of what we are now requesting, whether we defer the continuation of this examination until those submissions have come, or do we proceed?
The ministry, sir,
yes,
had made certain, taken certain positions, referencing their submission, so we might want to look at them.
Yes, but as I've said, I just was considering what Member Scaffrey had said, that if there is an exemption, then it may impact how we proceed.
I missed that.
Yes.
Sorry, Senator Scaffrey, I missed that.
Yes, so I think what we should do then is perhaps we will defer the continuation of this document until we have heard from the JDF, unless you otherwise recommend. Yes.
The committee is asking for more further clarification and documentation from JCF? Because, for instance, and JDF, because I'm just not clear. It's both, right? Both JCF and JDF. Because I'm not clear about the status of these civilians. Is it that they're not on their establishments? Because all of them have establishments. So I'm really not clear, because sometimes we can't just take a word of mouth kind of thing. We would need to see, is it that they are employed on contract? Is it that their contracts are different from others? I'm not sure of where the distinctions arise, but I know, for instance, they have like established posts. And I was wondering whether or not it is that the civilians are not on the established posts. And I don't have these answers. I just have been hearing they're different, they're treated different, and I don't understand why. So maybe if we could get that kind of documented evidence or information, then that would help the committee, not just somebody writing an opinion and making an assertion.
Quite right.
Yes.
In this world where recruitment of employees come in varying forms, and some might not be operating in established posts, but they might be employed on fixed-term contracts of varying natures, from even 3 to 6 months. I just put that out there. Or 6 weeks. But they have to be protected, and based on what we are suggesting in this piece of legislation, it governs the protection of all.
And Chairman, there's very few government departments that only have their establishment filled. Most of them are over and above the establishments. True, so we couldn't use that as the guide.
Yes. So the final comment on that, we will issue the letter to the JDF detailing the request of the committee in addition to the well, I think JCF had just, yes, they did not have any difficulty with the civilians based on my recollection, the JCF that is. It was the Jamaica Defense Force that made the submission for a total exclusion of not just the army officers, but the civilian.
Chair, the Ministry of National Security did include the JCF in their request. So, Ministry of National Security letter, which copied...
Oh, the cover letter you're saying that had an outright...
request of both agencies.
But I believe, and we are guided, but I think even though the ministry had made in their cover letter had indicated certain things, when the submissions were made by Ms. Alethea White, I think it was indicated that they had no difficulty. I think the point was even made that the civilian workers are usually directly to the Ministry of National Security. That's my recollection. I may be incorrect. But we will issue the letter to the Jamaica Defense Force, and we will be hoping that they respond to us in a timely way. Yes.
So, Chairman, I understand where you're coming from. I understand. But I think sometimes the committee can look in a wider context. An issue has arisen. And although the issue was specifically raised by the JDF and not the JCF, it occurs to me, though, that the issue could be applicable to the JCF. And in that respect, I still think there is no harm in us trying to even clarify the issue in relation to the JCF, because at the end of the day, the committee has a remit where when it comes on to looking at a bill and looking at the issues, you may realize that even though somebody has said A, you recognize that it impacts B, C, and D, and then you could go further and address all of those issues and not just A. So I don't think there's any harm in asking for the information as well from the JCF, and we could look at it in a more holistic manner.
Well, in that regard, we will proceed to issue a letter to the JCF. So we have taken on that recommendation. So with that said, members, I believe that it is a convenient time, since we had originally given an assurance that we would adjourn at 12:30. The next scheduled date, members, is on Monday, which should be the 23rd. Yes, on the 24th of February, and we meet at our usual 10 a.m. So maybe, yes, member? Definitely. So next week we will also consider for the month of March. Yes. On Monday we end at 12:30. Yes, 12:30. Yes. Hopefully on Thursday, which we will confirm on Monday, we will have an extended sitting.
On Thursday?
On Thursday.
Data protection.
Okay, fine.
So
I'm told on Thursday we have to do our. Yes. Yes.
So
Yes, Mr.
Monday is 10 to 12:30,
Yes.
and Thursday
Thursday will be 10 to 12:32 because I'm
Okay.
told data protection is at 2.
is... Okay.
Yes. Yes. Yes.
This is why the Standing Finance Committee was cancelled to facilitate us meeting on Monday.
Well, thanks for that information.
I just asked you. You didn't know the Standing Finance Committee.
I was preparing to attend.
I just want to extend apology for lateness on Monday. I have another meeting at 7:30.
I
So
understand.
it'll be about 10:30 there. About.
I understand. You're usually present and early. Yes. So may we have the adjournment, members? Yes. Member Longmore, seconded by Member Clark. Yes.
They up on the ready man a ring the alarm, so them coulda never try take the king for your man. Touch the stage anytime it perform then, best believe everything